Hey, aloha, everybody. Oh, I'm not in Hawaii. Sorry about that. Welcome. Glad you're all here. I'm Jeff Portnoy, the new chair of the society. I want to give a special welcome to all the judges and court staff that are here. And I generally want to make sure that we thank all of the sponsors who Johanna will thank individually. I want to take a second to recognize and thank our former executive director who is here tonight. Robin, if you'll come up, we have a small gift of appreciation for all of your fabulous 8 years. We have a very fascinating panel tonight. I just, some of you know, flew in from Istanbul a few hours ago and learned we have an election coming up from some of the people I met in Turkey. But I'm delighted to turn to the panel. We have a panel that is known for their expertise on issues that couldn't be more timely on elections, free speech, social media, and more. We are so pleased that Professor Abby Wood will moderate the panel. Professor Wood is a professor of law, political science, and public policy at the University of Southern California. Professor Wood earned her undergraduate degree from Austin College and her JD from Harvard Law School. She holds a master's in law and diplomacy from the Fletcher School at Tufts and a doctorate in political science from Berkeley. Professor Wood served as a clerk for the late John Noonan of the Ninth Circuit Court of Appeals before joining USC. She is an acknowledged expert in campaign finance and ethics laws. Not only does she have a deep scholarly knowledge of these areas, she has practical experience through her current service as a commissioner on the California Fair Political Practices Commission. Professor Wood has recently undertaken projects on regulating false political speech on social media. Does that include eating dogs and cats? And the effects of Citizens United on political donors. I'll turn it over to Professor Wood to introduce our esteemed panel.
Great, thank you so much. It's so nice to be here. So I have the great honor of moderating a panel. And today we have Eugene Volokh and Rick Hasson with us. And I've got their bios here that I'll read for you. So Eugene Volokh is the Thomas M. Siebel Senior Fellow at the Hoover Institution at Stanford and the Gary T. Schwartz Distinguished Professor of Law Emeritus and Distinguished Research Professor at UCLA School of Law. In his 30 years at UCLA, he taught First Amendment law, a First Amendment amicus brief clinic, tort law, criminal law, copyright law, and firearms regulation policy. Volokh is the author of the textbooks, The First Amendment and Related Statutes, and academic legal writing, as well as over 100 law review articles. So that's Eugene Volokh. You guys have the same chair.
I took it from him.
Well, how about that? So Rick Hasson, well, here we go. Rick Hasson is the Gary T. Schwartz Endowed Chair, if that sounds familiar, that's what we were just saying, in law, professor of political science by courtesy, and director of the Safeguarding Democracy Project at the UCLA School of Law. He's an internationally recognized expert in election law, writing as well in the areas of legislation and statutory interpretation, remedies, and torts. He is co-author of leading casebooks in election law and remedies. He served in 2020 as a CNN election law analyst and as an NBC News MSNBC election law analyst in 2022. He's one of the founding co-editors of the quarterly peer-reviewed publication, the Election Law Journal, which is a fantastic journal, not only because I'm sure all three of us have published in it repeatedly. He's the author of over another 100 articles on election law issues, published in numerous journals, including all of the law reviews you can name. So that's Rick Hasen. All right, so I thought we would structure the conversation by doing kind of a bird's eye view over big money in politics first, and then move into some technology related issues. And so for big money in politics, according to Open Secrets, oh, before we get going, I should say I am not speaking on behalf of the FPPC. That's the commission that I serve on in the state of California, not here on that in that capacity. I'm here in my professor capacity. So according to Open Secrets, the 2020 presidential election cost $6.5 billion. That, I just looked it up yesterday, is larger than the GDP of 42 countries. This cycle is shaping up to be expensive too. Outside spending in this cycle is outpacing prior cycles already, including the massively expensive 2020 election. Individuals and corporations, as you read in the materials, can give unlimited amounts to super PACs, and several in this cycle that I was just looking up last night hold well over $100 million that they can spend to support or oppose candidates. The court's rationale for allowing unlimited outside or independent money is that the main risk of campaign finance money is quid pro quo bribery. And if outside groups like super PACs created in the wake of Citizens United are actually independent from campaigns, there simply cannot be any quid pro quo bribery that happens. Therefore, limits on outside money raised and spent independently of candidates would suppress constitutionally protected speech. Of course, we know that there are several methods of coordination that can lead to circumvention of the existing limits, including, maybe you've heard of red boxing, when a candidate has information in a red box on their website that they intend for the outside groups to use, or sharing polling results or ad buy plans in public forums. So far, arguments about these behaviors circumventing campaign limits have not succeeded before the FEC for kind of detailed regulatory reasons we can talk about. So there's a lot of money, a lot of it from very wealthy people and corporations in our political campaigns. Meanwhile, according to the Federal Reserve, depending on the year, 35 to 40% of Americans surveyed report that they cannot cover an unexpected $400 expense in a given month. Moreover, only around 1% of Americans donate above $200 or more to a candidate in federal campaigns. So it's clear that the typical donor is much wealthier than the typical voter, and certainly than the typical constituent. So all that is a big windup for me to ask Eugene, how should voters and constituents think about our campaign finance system? If we listen to campaign rhetoric, many voters can't afford groceries, yet our campaigns are supported by donations from individuals who give tens of millions of dollars. Does this inequality undermine our democracy, or is it just the price of our freedom of speech?
So I think these are great questions. The answer might be both. And I want to try to approach it from two perspectives, which are just nothing is fresh in this area. Everything's been said already by too many people to count, but maybe a little bit different from what we'd heard before. So one thing, let's just go back, long time ago, an entire 2 months, feels like an eternity. Joe Biden was the candidate, the Democratic candidate for president. And then came the debate, the first debate, and you saw a lot of people saying he's got to go. And who was saying that? A lot of people were saying that. Relatively few, as I understand it, elected politicians at the time, because it's very difficult for them to do that. Both they're maybe afraid of retaliation, but also may just feel a loyalty to the party. Media people were saying that, and I think it's pretty acknowledged that that's part of the media's role. Although if you care about inequality, surely that that's a very serious inequality, right? If somebody who's in the media says something, that's paid attention to, even with social media, which equalizes things in some measure. Still, if somebody who's writing for the New York Times says something, that's a lot more people pay attention than if some ordinary Joe says it. And of course, donors, right? This is a big part of the story, that big donors are beginning to defect. George Clooney, who's obviously he has also perhaps an unfair, but still in a free country, an inevitable advantage in speaking out because he's famous. But also my understanding is when he helps organize fundraisers in Hollywood, he's a bundler, essentially. He's a kind of very famous, good-looking bundler. So people started talking, oh yeah, the donors are defecting. And this is just a part of the normal cycle, right? Normal news cycle. Yes, the donors are defecting. How's that going to affect things? And I mean, I have to say, as somebody who's skeptical of campaign finance regulations, I think even I have to be uneasy about the notion that, well, whether donors are or are not defecting is going to influence whether the president is going to step aside or not. Now, in this case, I think I'm a Republican, but I think even objectively, I think it's got to be the right thing for the country that Joe Biden stepped aside. So I think it was good that the donors stepped in, but one has to be uneasy in a democracy when that people have that kind of disproportional influence. Although again, maybe one should be uneasy about the New York Times journalists having disproportionate influence, or Taylor Swift or George Clooney or whoever else having disproportionate influence. The second thing, it has to do with the net choice cases, which we're going to talk about shortly. And the courts concluded that by basically a 6-3 vote, that it's unconstitutional for state governments to try to impose viewpoint neutrality rules for social media platforms because it trenches on social media First Amendment rights. Well, if Citizens United came out the other way, we might ask, what First Amendment rights? I mean, they're all corporations. They're much wealthier corporations than Citizens United, right? If you're worried about companies like Citizens United or the corporations that donate to Citizens United having a disproportionate influence on American politics, surely you should be worried at least as much about Facebook and Google, and Twitter is a less wealthy but still very influential company. And in fact, the Florida law was specifically a law that was aimed at, in part, what Florida might label election interference. It was particularly aimed at deplatforming of political candidates, right? So I think Citizens United is right. I think Buckley is probably right. And I think probably Net Choice on its particular facts is right. But I do think it's important to recognize how everything is connected here. That if you do think social media platforms have First Amendment rights and it's unconstitutional for state governments to try to equalize things, try to prohibit viewpoint discrimination, try to make them common carriers, then you're kind of saying that corporations do have the right to speak, including to speak on matters closely related to elections, as well as further related to elections, like things like blocking stories about the Hunter Biden laptop. It wasn't exactly express advocacy, but it was certainly something that might affect elections. So those are the things I wanted to flag. How ultimately what the right answers ought to be, I have my sense, but again, there's nothing terribly novel about it. But I do want to mention these two connections because they're things that came up just this summer and that we ought to think about, I think, as we think about the big picture, the kind of the enduring questions.
You want anything on that?
Sure. So I can say that I believe it was 25 years ago that Eugene and I did an event at the California Club on the same topic with Manny Klausner.
Everything old is new again.
And I think maybe 15 years ago, I did something with Ted Olson at the California Club on the same topic. So if there's one thing Eugene and I can agree upon, this is not a new topic. And we can talk about the super PACs and some of those details in a bit, but let me give you where I am now, which is somewhat different from where I've been, which is that right now, I think when it comes to money in politics, we have the worst of all worlds. We have a Supreme Court that has struck down some campaign finance laws, but not bothered to strike down other campaign finance laws that seem like they would no longer be valid under cases like Citizens United. So we have a system where there is the illusion of regulation. And this can be a trap for the unwary. It can be a trap for the person who's not sophisticated in politics. You want to spend money in politics in any significant amount, you got to hire a lawyer, right? So we've got this system that the little person can be trapped. And yet it is now regular that we have people contributing over $100 million in an election campaign. Some on the left, Michael Bloomberg, some on the right, Sheldon and Miriam Adelson, over $100 million. We never had a situation like that until after Citizens United. And it's not the holding of Citizens United that caused that. It is the Citizens United framework that has been applied by other courts in cases like the Speech Now case from the DC Circuit that led to the creation of super PACs. So right now, if you want to have tremendous influence over an elected or a candidate running for office, you can only give, if we're talking about a federal office, you can only give that candidate $3,300, or maybe now it's up to $3,400 for the primary, and again for the general election. But you can give unlimited sums, and some people are giving millions to an allied group that gets the blessing of the candidate that might be staffed by the mother, I'm not kidding, the mother or the spouse or the former campaign official of the candidate. So if we're worried about corruption, we're worried about influence of money in politics, then we essentially have the illusion of regulation, and that doesn't do anybody any good. What I would say is that the problem is not Citizens United. And I'm not sure that Citizens United was even wrongly decided. The problem is Buckley versus Vallejo. There's a line in a case called Austin, which is a case that got overturned in Citizens United. There's a line in Justice Scalia's dissent in that case, where he's complaining about the court okaying limits on corporate spending in elections. And he says, well, why is it okay for the individual billionaire to give whatever sums they want? And that's exactly right. He was saying if we're not going to stop the billionaire, we shouldn't stop the corporation. I would say let's stop both the billionaire and the corporation. That the problem was almost 50 years ago in Buckley versus Vallejo, when the court refused to consider equalizing the playing field as a potential permissible inference to justify reasonable limits on money in politics.
They've just scooped almost my entire question list with that, I will have you know. So this might get a little freewheeling here. So this is a very narrow regulatory question, very tied to what you were just saying, but just to bring it out for the audience. So the Federal Election Commission, just in the past couple of weeks, had, I think it was a Lindsey Graham. I think Lindsey Graham had challenged an existing regulation, or maybe made a request for rulemaking. I don't remember the procedural thing that happened, but anyway, it was a Lindsey Graham thing. And he wanted to have his super PAC and his campaign form a joint fundraising committee. I don't know if I'm getting the particulars right, but basically, before the FEC went ahead and did what he asked for, candidates would appear at super PAC fundraisers, but they would leave the room when the ask happened. Okay. Now, they don't have to leave the room. And given the amount of coordination that we believe could be going on, which is, some of it is legal because of the public exception. If you coordinate in public, it's not coordination, says the FEC. And so they send cryptic tweets to each other and do this red box stuff, right? I wonder, and I think this is where you were headed before, what's the point of even having direct contribution limits?
Yeah, so yeah, let's just to spell out the logic here. The idea is that the Supreme Court in Citizens United, following Buckley, said that independent spending can't corrupt. This was it was a question about whether this was a finding of fact or whether this was a legal conclusion. I think it's better to think of it as a legal conclusion because there was a case right after Citizens United where actually out of the Ninth Circuit, American Tradition Partnership versus Bullock, where Montana said, we've got a different record of corruption. We should be allowed to do things. And the Supreme Court disposed of it, I think, in one paragraph and said, no, the same rule applies. But the idea is independent spending cannot corrupt. And so if independent spending cannot corrupt, so I'm a billionaire and I spend money to support Harris or Trump for president, can't corrupt. It only is corrupting if I coordinate with the candidate. So I call up the candidate and say, should I run ads on immigration? Should I run ads in Phoenix? What should I do? That's when you cross the line. When there's coordinated spending, it's treated as a contribution and then it's subject to the contribution limits. And so what Abby was referring to is what is the line on coordination? The easier it is to cooperate, the more you get closer to that risk of corruption. And what the FEC is doing is moving us closer to a world of really no contribution limits. And in a way, there are reasons you might want to give the money directly to the candidate, because one thing we know about outside groups, some of them are fly by night. The super PAC comes up for one election and disappears. They tend to run more negative ads. They tend to lie more. Candidates are worried about their long-term reputation. I'm not someone who wants to deregulate the system, but in some ways, deregulating the system completely would be better than what we have now, which is this illusion of regulation.
Thank you for that. So I'm going to head to Eugene next. But I'm going to take a little detour into my research for a second. So most of my research is about transparency and campaign finance disclosure. Part of the reason I study that is the limits and bans are a real Swiss cheese of regulation, and it's really hard to get any empirical traction on it, and I am an empiricist. But it's easier to kind of figure out the benefits of disclosure in an experimental setting, survey experiments. You can just ask people, right? You can just give them some information, see if they make different choices than the people who don't get it, right? And so I've done this whole series of papers where I look at and try to measure the benefits, the informational benefits that the public gets from campaign finance disclosures. And I've found they benefit. They really, they vote differently when they have more information about who's supporting which candidates. I've also done some studies trying to figure out whether there is what the court calls a chilling effect from disclosure. Okay, so the court says, well, there are certain groups who might really be deterred from donating because of who they are, and they don't want their affiliation with a certain candidate to become public. Okay. And specifically, the mechanism they're worried about is a risk of harassment, where, as Rick has said in an amicus brief, there's been very little documented harassment of donors, and there's millions and millions and millions, hundreds of millions of donations every year, right? But the court says, well, there could be chilling. So they're worried about it, okay? Well, one place I've thought to look for chilling, and I need more data, I've got a little, is in the workplace. If you think that your boss has a different political ideology than you do, maybe you're less likely to want to make a donation in public. So what does it mean to make a donation in public? You give a donation to a group that has to disclose, like a super PAC or a campaign, and you give above the disclosure threshold, or you give to a conduit like Win Red or Act Blue, because they have to disclose too. If you give less than a disclosable amount, or you give to a dark money group, then you won't be disclosed. And that part's kind of hard to observe. But anyway, it's a little hypothesis I have that particularly within the workplace, we really might observe some chilling. And so we were having an email exchange this week about this panel, and Eugene mentioned legal protections for employees for their political activity. And so I actually just want to toss the floor to you and ask what you've been thinking about, whether you think my intuition might be right, what other political activities you think you'd want to protect, and where the constitutional limits on all this are.
Sure. So if you look at the history of employment discrimination law, and you look to see kind of how it evolved, of course, in 1964 Civil Rights Act, there was a federal prohibition on discrimination based on race, religion, sex, national origin, then later age, disability, sexual orientation, variety of things. But if you go back, and especially to the state level, what is the first prohibited basis for discrimination? It wasn't race, it wasn't religion, it wasn't union membership, although that was pretty early. It was voting. Starting with the 1830s, states prohibited employers from threatening retaliation against employees based on how they voted. Starting with the 1860s, that shifted to actually prohibition on employers dismissing employees based on how they voted. Because if you think about it, any such dismissal, if publicized, becomes a threat for the future. Then, starting in the late 1860s, this extended beyond just prohibition on discrimination based on voting, but also in some states, prohibition of discrimination based on publicly supporting a candidate. Interestingly, this did not emerge as state statutes or as common law rules or state constitutional law rules or local ordinances. They emerged as military governor orders in South Carolina and Louisiana, where the concern was that the Democrat plantation owners were threatening their employees, both freedmen, but also just poor whites who might otherwise find the Republican Party attractive, that if they voted Republican, they'd be out of a job. And if they supported Republican candidates, they'd be out of a job, publicly supported. Now, of course, as to voting, what made all of this an issue is this was before the secret ballot, right? So this has to do with this whole transparency point, that there are benefits to making political activity transparent, but one of the costs is people will be reluctant to vote their conscience if they know they might be fired or actually otherwise retaliated against. In some states, there were prohibition on any kind of economic threat, not just a firing, but I'll stop doing business with you if you vote a particular way. That was illegal, but not just tortious, it was a crime. And interestingly, this wasn't in labor codes, labor sections of the statutes. There weren't a lot of labor regulations at the time. This was in the election law statutes. It was right next to the prohibition on bribery. The theory being is if you pay someone money in order to vote a particular way, that's a crime. Well, if you threaten to take away the money, take away this person's livelihood, if they vote a particular way, that should be a crime too. So at this point, pretty much in every state, it is illegal to discriminate based on how someone voted, largely moot because we are on a secret ballot. But about half the states have one form or another prohibition on private employer discrimination based on political activity. Not often litigated. In some states, it's basically unknown. California actually has a decent amount of litigation. I should just note, I'm involved in one such case. I won't give any further details on it, but I am actually acting as a lawyer in one such case, just FYI. But there is a prohibition on firing based on political activity, which has been interpreted quite broadly to include any kind of advocacy of a candidate or a cause. In Washington state, it's a prohibition of firing based on campaign-related activity. So supporting or opposing a candidate or a ballot measure, including through contributions, I believe, and also through public statements. In Seattle, interestingly, there's an ordinance which actually applies it, creates a much broader prohibition, about as broad as California's. If I recall correctly, Arizona and New Mexico, excuse me, New Mexico is not in the Ninth Circuit. Forget New Mexico, who cares about that? I think Arizona and Nevada have statutes similar to California's, although maybe somewhat narrower. Oregon doesn't. Oregon doesn't have any such statute. A few states only prohibit discrimination based on having given a campaign contribution. Interestingly, my sense is if an employer says, we will fire you unless you give a campaign contribution, that's actually already illegal. Because that is basically, I think, kind of like a conduit donation. I'm essentially saying part of the money I pay you as your salary, I insist that you donate to this candidate. That's already a crime, at least in those states that limit campaign contributions. But not necessarily so if we say we'll fire you based on that. Now, you might say there's actually not that much of a problem. There are a decent number of cases that are made public every year about where people are fired based on various kinds of political statements. There were such things, especially with regard to the anti-same-sex marriage campaign in California. And there was also there were these maps of contributors so that people's home addresses were essentially shown. And I think the whole message was, we know who you are. If you contribute, you're going to get retaliated against in one form or another. So maybe this is not that much of a problem. Maybe it's not worth extra burdens on employers. But there is talk about whether something like this should be present at the federal level. Whether as to campaign-related speech only or as to political speech more broadly. Interestingly, religious speech is, of course, protected by Title VII. And indeed, if somebody is fired because for religious reasons they speak out about politics, they may have a good religious accommodation claim on the theory that this was the religious practice to witness to what they think is the godly course of action. So one interesting question is, to what extent should the law do the same with regard to political speech more broadly, whether defined narrowly or broadly? As I said, about half the states do that in some measure. And it's an interesting question, both what constitutional limits, if any, there are on that, and whether that should be generalized at the federal level.
Isn't boycotting protected First Amendment activity?
So the answer is no. And one way we know this is the existence of anti-discrimination law, right? Every time somebody says, I don't want to hire Catholics, you could say, well, that's basically a boycott of people who support this particular ideological movement and institution. And the answer is, a boycott is conduct. A boycott is concerted refusal to deal, or maybe not even concerted, just refusal to deal. It's not speech. The same issue has come up with the anti-BDS statutes, which prohibit contractors from engaging in boycotts of Israel and Israeli affiliated companies. And the one case in which this was decided on the merits by a circuit, the Eighth Circuit en banc, by a 10-to-1 vote, said that there is no constitutional right to boycott. There is a constitutional right to urge people to boycott things, especially when the boycott would be legal. But if the law says you cannot boycott people because of their religion, or because of their sexual orientation, or because of their support for anti-discrimination claims or whatever else, or because of their politics, I think that would be constitutional.
You have anything on that?
Not on the employment side, where Eugene knows much more than I do about this topic, but I do want to talk about campaign disclosure. So the Supreme Court has long said that disclosing campaign information serves three important government interests. One of them is it can deter corruption. If I see all this money is going to this candidate, then I can try to follow the money and see if there's something nefarious going on. Also, the information interest. The idea is, if I tell you there's a ballot measure on the ballot, I'm not going to tell you what the substance is, but it's getting major funding from people who support Planned Parenthood and lots of opposition from the NRA. You might know how you want to vote on that just based on that information. That is, voters are busy, they're not stupid. They use that information as a cue to shortcut to figure out how they're going to vote. And the third is to help enforce other laws. So for example, if we don't allow foreign nationals to contribute to campaigns, disclosure would let you find those people. So as Abby said, there's an exception to this. Buckley recognized that there's a case called Brown versus Socialist Workers Party that said, if you face a risk of harassment, then you could get an exemption from the disclosure laws. And the Socialist Workers Party case, the FBI was literally going to people who were members of this party and going to their employers and going to their landlords and trying to get them fired and kicked out of their homes.
Well, the FBI was surveilling them too.
So there is some evidence of harassment. I think there's not that much evidence of harassment for the person who gives the contribution, but there's a different interest as well, which is the interest in privacy. Not that someone's going to be harassed, but I live in a very liberal neighborhood. I can look up and see which of my neighbors are giving to Donald Trump, and I have that information. And someone might give $210 to Donald Trump, and I'd be able to know that because that once you hit the $200 threshold, it's publicly disclosed. I don't think knowing that my neighbor gave $210 is going to deter a lot of corruption. I don't think $210 is going to corrupt a candidate. It's not giving me valuable information to know how I should vote. And, it's not really serving the enforcement interest either. So I don't think as a constitutional matter, there's a problem with the $200 limit, but I think as a matter of policy, and now you can't speak because you're on the FPPC, as a matter of policy, I would like to see the thresholds for public disclosure raised. I still want the information given to government officials, but why don't we focus on the big money? Someone who's giving $10,000, $20,000, that's where the government has, or $1 million, $100 million, that's where there's much more of an interest in deterring corruption and in providing voters with valuable information.
I will say, I have a study in Seattle. We got the ideology estimates of every single voter and registered voter in Seattle, because Seattle sends out $100 of campaign vouchers and $25 units. And we then looked within zip codes at each donor. And we were wondering if people who, like in your liberal neighborhood, you've got this Trump donor, would that person be less likely to give money that's kind of sincere with their estimated vote preferences or not? And we found the opposite. We found that they were actually giving to the more extreme candidates. This was all for city council, so much smaller stakes, but I thought it was really interesting. Now, we don't know which people put their vouchers in the recycle bin because they were fully chilled. But we know that conditional on giving, there was no chilling from being kind of the ideological minority in your neighborhood. That was kind of a cool little finding, because I would have expected the opposite, that maybe they would shade a little more toward their neighbors. So, okay, let's change topics. Let's talk about technology and campaigns. So in case there are people in the room who didn't get to all the reading, you've got 3 professors up here, but I thought I would just summarize these cases very quickly for you. So the Supreme Court has weighed in on social media regulation recently in 2 cases in which the government tried to influence content on social media platforms in a direction that angered conservatives. Both of these were challenges raised by conservatives. So in Murthy v. Missouri, plaintiffs challenged Surgeon General Vivek Murthy's health advisory that encouraged platforms to take steps to prevent COVID-19 information from taking hold. They did not include the platforms in the list of defendants that they were suing. They sued Vivek Murthy. The court said that the plaintiffs did not have standing to sue, including on a listener interest claim. And they cited cases about injury in fact, they cited cases about causation and cases about redressability. In Net Choice, the plaintiff, Eugene talked a little bit about this case already, but the plaintiff social media companies challenged regulations in Texas and Florida, which were aimed at stopping what lawmakers in those states viewed as suppression of conservative speech. In particular, the laws restricted the platform's abilities to filter, prioritize, and label the varied third-party messages, videos, and other content that their users wish to post. Both laws also included individualized explanation provisions, requiring a platform to give reasons to a user if it removes or alters her posts. The major platforms allege that the laws infringe on their constitutionally protected editorial discretion. The Supreme Court remanded, giving quite the clinic on First Amendment law in the process. They summarize, after this whole, I call it a clinic, they summarize some general points that emerge. And Eugene already summarized these, but I'll just give them to you one more time. So the first thing was that the First Amendment does offer protection to entities that compile and curate other speech into an expressive product of their own. So this is the idea that each of us have individual news feeds on these platforms, and they are curated for us basically by an algorithm. And what we see is a protected speech product or expressive product of the platforms. So these platforms have protection against directions to accommodate messages they would prefer to exclude. And that is true even when they're only excluding a few messages. The second kind of general point they say, which will not be surprising, is that the government cannot get its way just by asserting an interest in better balancing the marketplace of ideas. Okay, so that's the background. So Eugene, you already previewed your answer here, but were these questions correctly decided? And then a second question is there a version of the Murthy case that could reach the merits? And if so, how would that case come out?
Sure. So let me start with Murthy. So one of the interesting thing about the standing reasoning in Murthy is it said these particular plaintiffs did not have standing because it wasn't clear that their speech was restricted as a result of what the government was doing. It was certainly unclear that it would be restricted again in the future because of that. But presumably, the government was talking to the platforms and urging them to block certain speech for a reason. Presumably, it wanted somebody's speech blocked. And seems pretty likely that it succeeded, at least to some people. Maybe not these particular plaintiffs, but somebody out there you'd think would fit in the category of people whose speech wouldn't be restricted normally by the platforms, but was restricted by the platforms once they heard from the government and the government said, please restrict this. Now, maybe you can't find these people. Maybe they don't know for sure who they are. Even if they do know who they are, they won't get hooked up with the right lawyers and such. But that question, what do you do about them? It remains unanswered. Now, if what had happened was that the government coerced the platforms through threat of retaliation into removing certain material, that would be unconstitutional, and we know it from a case, NRA v. Bulo. I should say here as well, I was actually one of the lawyers for the NRA, though David Cole of the ACLU was another of the lawyers, and in fact, he argued the case. And the court unanimously held that when they knew, that at least NRA alleges that the New York financial authorities pressured various financial institutions to stop doing business with the NRA because of the NRA's positions on gun rights. And that the court said that allegation is sufficient to state a First Amendment claim. But the hard question is what happens if this isn't coercion? If it's just the government sort of trying to persuade the platforms to say, look, you know, this is bad speech. We want to persuade you that it's bad speech, that you should, as good citizens and good stewards of the interests of your users, block access to this speech. That's the really tough question. So let me tell you, give you two things just to think about with regard to that. One is something that Kavanaugh, Justices Kavanaugh and Kagan, both of whom had worked in the White House, had pointed out. They said, you know, people in the government call up people in the media all the time and say, why did you run this op-ed? It's a bad op-ed. It's wrong. It's misleading. It's bad for our diplomacy. It's bad for various ways. And some of the time, in fact, it's false. And we think we're doing you a service by alerting you to this error and doing your users, customers, whatever they are, subscribers, let's say, or users, a service. So it can't be the case, I think, that every time the government asks someone to restrict speech on their platform, that's unconstitutional. Although one wonders if it might be the case that if it's systemic enough and organized enough, if the government is trying to do things indirectly that it couldn't do directly, that would be impermissible. So that's one thing. That's an argument as to why the so-called jawboning, that's the term that has emerged for this, is just fine. Here's the argument on the other side. So I happen to own some rental properties. Probably many of you do too. So let's say the police department calls me up and says, Volokh, we think one of your tenants is engaging in some crimes. We don't have enough to get a warrant. But we know you don't need a warrant because under your lease, just because most landlords, this is the case, you can go and you can inspect the property. We should stress, we are not trying to coerce you into anything. If you say you don't want to help us out, that's fine. We promise we will not retaliate. We're just appealing to your good citizenship. we hope that you would help us out because these are serious crimes that this person is accused of. So if you just look around, you just say you want to do an inspection, and in the meantime, look around and just to see. We're not even saying break open the drawers to his desk. Just nose around and tell us what you find. That would be a Fourth Amendment violation. I would become actually a government actor. There's case law on this, including from the Ninth Judicial Circuit. I would become a government actor. I might myself, therefore, be sued under Section 1983. But even setting that aside, the government can't use the fruits of that search. So why? Because the government can't use private power as a way, coupled with its persuasive force, as a way of evading the limits on government power. And that's true for the Fourth Amendment. It's true for the Equal Protection Clause. It's true for interrogations. Why shouldn't it be true as to speech restrictions? So that's what makes, I think, more the case. Let me turn to net choice. So net choice, here's one way of thinking about it. Think of a spectrum, of a platform spectrum. On one side are newspapers. Indubitably, they have the First Amendment right to pick and choose what goes in their pages. And incidentally, the First Amendment here follows practicality because they have to pick and choose. And in fact, a huge value that they provide to you as the readers is the picking and choosing to deal with problems of information overload and misinformation. We might be very skeptical about the government trying to block misinformation, but a newspaper that refuses to block misinformation from its pages is a lousy newspaper, right? So newspapers, magazines even more famously ideological often, maybe bookstores. There could be a feminist bookstore, a free market bookstore, a Christian bookstore, a Marxist bookstore. That's one end of the spectrum. Here's another end of the spectrum, the phone company. The phone company can't say, well, we just don't like the fact that the Klan or the Communist Party happens to have a get out the vote line or a recruiting line on our service. We're just going to cancel their phone line. They can't do that. They're common carriers. That's true if they are landlines, monopolies, or the famously competitive cell phone companies. And in between, there are other interesting places. So for example, in California, shopping malls are not allowed to exclude speakers. The Supreme Court has said that universities may be required to host military recruiters, even if they'd rather not. So as property owners, just owners of real estate, one generally doesn't have the right to pick and choose. If the government wants to say you're a quasi-common carrier, it can. Newspapers are different. So then here's the question. Now, this is the last point I want to make about net choice. As to each function of a social media platform, where do you put it on the spectrum? And this is something that both the majority and Justice Jackson in her very short concurrence stressed. You can't think of the rights of social media platforms, period. They have different functions. As to they're producing a curated, coherent speech product, the news feed, 6 justices say that's First Amendment protected. But what about their ability to deliver direct messages? Or what about when social media platforms just provide an email service? The justices suggested maybe that's more like a phone company where maybe some sort of common carrier rule is permissible. What about their decision to just completely deplatform users, like the ban on Donald Trump in the wake of January 6th? That's something that's not resolved by net choice. So it turns out that net choice both recognizes the spectrum and recognizes the different features, different functions of the platforms can fall in different places in the spectrum.
Thank you. So we are 2 minutes over, but I want you, the boss of cheap speech, he has a book called Cheap Speech, to just give us a little prognostication, not as to who will win, but as to how these cases will affect the 2024 campaign.
You know who came up with the term cheap speech?
I do not.
Eugene Volokh in his article.
It's just like the Gary Schwartz thing. We're both Gary Schwartz. We're both a cheap speech.
Oh, that's right. You wrote like an article like 20 years
Cheap speech
before.
and what it will do.
That's right. Oh, I cited that too. Sorry.
So Eugene used the term cheap speech as in cheap will be inexpensive. And it truly is that, if you didn't like something in 1985, if you didn't like something in the New York Times, you could send them a letter and that would be the end. Now you can go on every social media platform and get out. I use cheap speech in that sense, but also in the sense that lower valued speech has a benefit, has an advantage in the market. It's a lot cheaper to produce fake news than to produce real news. And there's a problem with information that is, the idea of the marketplace of ideas of truth rising to the top. We know that's not always true. One of the reasons we know it's not true is because there are millions of people, at least who tell pollsters that they believe the last election was stolen, and there's no credible evidence that the last election was stolen. So this was one of the key issues in the NetChoice case. Both Florida and Texas passed laws that essentially would have banned Facebook and Twitter from removing Donald Trump from the platform. And I filed a brief along with a few other scholars in the NetChoice cases saying that this is a private choice to make as responsible corporate citizens. Just like a corporation might choose not to give money to an elections denier, a corporation might choose not to have that speech on the platform. And yet, under the rules in Florida and Texas that were put forward, that the speech from a politician would have to be carried, even if it called for, go to the Capitol and, do what you have to do, as long as it avoided, what I say is the actual threat that would be removable under the First Amendment, then there could be lots of incendiary speech. And, when I wrote that brief, dropped a footnote and said, things might change when Elon Musk takes over Twitter, now X. And just because I don't like what Elon Musk is doing, I still think this is an editorial choice. And people vote with their clicks and their eyeballs. And there's a reason why Twitter's advertising is down 75%, because a lot of people don't like the product that's being made. And as much as I think there's some trouble with the marketplace of ideas approach, the idea that we were going to have government mandate that even potentially violent and undermining of the speech that's undermining democracy would have to be carried by a private actor, of course that changes the nature of the coherent speech product that a platform is putting together.
Thank you. So I think we got a little time for Q&A. You're gonna have a mic.
10 to 15 minutes of
Right?
Q&A.
We got 10 to 15 minutes. Got a hand in the back.
I'm going to hand you. I'm aware of stuff already. I'm in Nevada, swing state, and I just became aware of a ACLU case about observers at the polling place. And I suspect it's kind of, one of many that are going to be happening.
Following the
I'm not familiar with that particular case. What I can say is that the litigation situation in 2024 is greatly improved. And I've said this and people said, you're always really pessimistic. So let me not be pessimistic for this moment. The litigation situation is improved from the situation in 2020 because we're not having a pandemic. And during the pandemic, there were lots of states that changed rules. And there were lots of states that didn't change rules and then were sued. So there was a lot of change just before the election, a lot of litigation over it. That is gone. I would say that most of the litigation that we're seeing now in the states related to elections is smaller bore. It's not as consequential. There was a case, some of you are familiar with, went through the Ninth Circuit, went to the Supreme Court, involving Arizona's voter registration rules. There are some cases, it's a case in Pennsylvania before the Pennsylvania Supreme Court right now, about the treatment of ballots that are mailed in that arrive in a timely manner, but they are missing a date, or they have the wrong date on them, but they're timely and they're from eligible voters. Should those be counted or not? So there's some litigation. Let me say, in the period after the election, if we have a close election again, I also think we're in better shape, in part because Congress passed a law called the Electoral Count Reform Act, which clarified some of the rules for how Congress counts electoral college votes, makes it harder to send fake electors, which was one of the things that was tried in 2020. And also the Supreme Court decided a case called Moore versus Harper in 2023, which rejected the most extreme version of the so-called independent state legislature theory. Legislatures don't have freewheeling power, say, to replace the electors that state voters had chosen under a system that the legislature had already put in place. So I think we're going to see a lot of litigation, in part because campaign finance rules, federal political parties can set up litigation funds, but the litigation is so far not as significant. So I'm a little bit more hopeful.
Thank you. Professor Hayes, you said something there at the very end about the marketplace of ideas and how truth doesn't always necessarily like rise to the top. And so I'm curious as to if the answer isn't more free speech to like combat false speech, then what was the line? Where would you draw the line in the sand, or how would you encourage truth finding in a society where there is a massive amount of cheap speech that's drowning out truth?
Right. So the question is, how do you have a society that is committed both to the idea that we need robust, wide open debate about political ideas, and a society that wants to have free and fair elections, where you have some people that are undermining people's confidence in the elections? So in my book, I argue that only very narrowly defined categories of speech should be prohibited. So for example, someone lying about when, where, or how to vote. Democrats vote on Tuesday, Republicans vote on Wednesday, or telling someone to go to the wrong polling place. That sort of speech can be constitutionally prohibited. There's a Supreme Court case in 2018 called Mansky, where the court suggested that. Other than that, I think we need to have not speech that, not squelching speech, but instead giving voters additional tools. So let's take the question of deep fakes, for example. So deep fake is a manipulated audio or video, might make someone look like they're saying something or do something that they're not saying or doing. It could be a politician, it could be embarrassing. So how to handle that? I think that it should be constitutional. I'm not sure what the Supreme Court would do, to say that all deep fakes should be labeled, if they're posted on social media, they should be labeled as altered. That way, voters get additional information. Now, California just passed a law kind of like this, or the legislature passed it. I don't think Governor Newsom has decided whether or not to sign it yet. They have a law that says that you cannot do this. You cannot post a deep fake of a politician or election official unless it's a satire or parody. And then you have to label it as satire or parody. I think that's a terrible approach, because who's going to decide what's satire or parody? So I would label everything that's altered, unless it's altered in a very minor way, and I have a whole definition, as altered. So that's a way of giving voters more information. I would also extend the disclosure rules that apply. You know, right now, if you have a TV ad that comes to you through your cable box, there's certain disclosures that are required, but if it comes to you from Hulu, they're not. Because one's coming on the internet and one's coming on satellite. I mean, that's not a way to run elections. I want to give voters more information.
When you're discussing the campaign finance law and regulations, you're mainly focused on large donors, but in the last decade, I think the focus has shifted on to smaller donors on the internet, and the candidates seem, at least for the presidency, seem really focused on those donors, and everybody gets the spam texts and emails, and they seem to make a difference. So how does the rise of small donations change the debate about dark money, PACs, and then does it impact views on we should have about Citizens United and whether it was correct or not?
Do you want to?
No, it's all yours.
So we have, a bimodal distribution, I think a social scientist would say. There's lots and lots of small donors, and there's lots and lots of mega donors. But as Abby said, most people are not giving. It certainly has become cheaper and easier, which is why people get inundated with these text messages. It used to be you'd have to send direct mail, which is very expensive, and then wait for someone to mail back a check. I mean, so things have changed. When Barack Obama was the first major party candidate to reject public financing, he wouldn't make a deal with John McCain to abide by it. He said, "Oh, I have my own form of public financing. It's this." And then he, which was basically raise small donations privately, he outraised McCain, I think 7 or 8 to 1. So small donors are a major force in politics. I think that's a good thing. I actually support the idea of campaign finance vouchers. I want to give everybody money to be able to donate to candidates. So it would be public financing spread through voters. One of the reasons I think that's better is because here's what we know. Small donors and also large donors tend to be more extreme than the general public. So, oh, AOC, Marjorie Taylor Greene, they're saying something that's really getting me excited. I'm going to give money. And then you end up funding more extreme candidates. If you want to fund the middle, you need to give people who are not as excited about politics a reason to spend, and subsidizing it, I think would, so it's public financing, but rather than say collecting a number of signatures, you give everybody $50 that they can contribute to candidates. So I think that's a good way to try to approach public financing. And I don't think the fact that we spend X billions of dollars is a problem. I don't know how much we spend on potato chip advertising. It's not, but the total amount of money is not the problem. It's very expensive to reach voters. Voters have better things to do than to pay attention to political ads. The problem is when one individual or group has so much influence by giving so much money, influence both over who's elected and also over what policies they follow once they are elected.
I want to say one thing about the small donor ideology thing. This is something that other professors have said too, and it's not that it's wrong. It's that I think that I think it could be. I think it's very possibly wrong, but here's why. When we talk about AOC and Marjorie Taylor Greene, we're looking at recipients who are largely funded by small donors, but that doesn't mean that most small donors are ideologically extreme, because most small donors could be giving in the middle. And I've got to write this article up, and I haven't done it yet, but it became kind of something people started to say is small donors are so extreme, small donors are so extreme. But it's more like the big donors won't give as much to those extreme people, and instead they're relying entirely on small donors, but it doesn't mean that that's where all the small donor money is. So we just have to be careful when we talk about it, and I got to write it up. It's with what time? He has 28 talks this month or something. Like, you're not going to be able to follow up with him. This is your chance.
In that case, then I'm just going to ask for a big round of applause for our wonderful panelists.
You guys are great.
As I think you heard Professor Wood say, Professor Hassan said that he had 28 talks this month. Say again? This month before that. So we feel truly honored that these three extraordinary scholars have spent the time today to come and speak to us. And we have just a little thank you to provide. This has given a lot of food for thought. I might be, following up in the next couple of months with my questions, burning questions. I want to say thank you to everybody who is here tonight. And let me introduce myself. This is the first time that I've been able to be on this stage. My name is Johanna Hartwig, and I am the new Executive Director for the Ninth Judicial Circuit Historical Society. I'm so It is so kind of you. We really appreciate each and every one of you coming here today. As I'm sure that you know, the mission of the Society is a very important one. It is to preserve and promote the vibrant history of the law in the Ninth Circuit and to raise awareness of the important role that the judicial system plays in our society. There are 3 activities that we undertake in order to accomplish our mission. The first one is engaging and enlightening and relevant programming that draws on issues of legal history that are relevant to us today, programs like the one that you just heard today, or like our upcoming programs that we have. We have 2 fascinating programs that'll be coming up and several others in the works. In a month in October at the wonderful Kennedy Learning Center in the Eastern District of California, which is in the Matsui Courthouse. We're going to have 2 perspectives on the Japanese American internees who resisted signing the loyalty oath. And we're going to be showing a short documentary about an attorney, Wayne Collins, who successfully represented these resistors. as well as viewing a graphic novel about the same people. And we're going to be having a conversation with the director of the documentary and the author of the graphic novel. It should be really fascinating. And as with all of our events, it will be streamed. We hope that you will join us. We have several other interesting things in the works. We're going to have a panel on gambling law on November 12th at UNLV in Las Vegas. And that's an accompaniment to our extraordinary last double issue of our journal, the Western Legal History Journal. That is also going to be very interesting. If anybody feels like a trip out to Vegas, that will be worth it. And we have many other interesting panels coming up. So that's an important part of the work that we do. Another important part is the Western Legal History Journal that I just mentioned. The sincere thanks of the Society is given to Judge Michael Daley Hawkins, who is the dedicated and energetic editor-in-chief of that journal. And as I think you know, there's really fascinating and really compelling work that comes out in that journal. Our last double issue, as I said, was on gambling law. The one before it was on water law. So issues that really resonate across the circuit and throughout our membership. And the third part of the work that we do is capturing oral histories, now by video, of judges within the circuit, as well as prominent attorneys, so that we can host those as a way to capture and share the extraordinary achievements and lives of the bench throughout the circuit. So those are three things that your support of our society makes happen every year. And I want to take a minute to provide some more additional thanks. First, I would like to give a true thanks to all of the district courts and the Court of Appeals for the Ninth Circuit. A very sizable chunk of our funding each year comes through grants we get through the attorney admissions funds, which are dispersed by the courts in order to benefit the bench and bar. And we are very proud to do that through our work and extremely grateful to the courts to support our work. And we are also very grateful to all of our sponsors today who make not only this lovely gala happen, but really support our work through the rest of the year. So I'm going to take the time to go through those. This year we have different levels. This year at the diamond level, Denton's and Gibson Dunn supported us. Thank you so much. At the platinum level, Larson LLP, Morrison Forster, O'Melveny, Perkins Coie, Sussman Godfrey, and the Wilson Sonsini Foundation. At the gold level, BG Law, Varela, Braun and Martell, Wilkie Farr and Gallagher. At the silver level, Horvitz and Levy, Kendall Brill Kelly, Pillsbury, and Winston and Strawn. We have virtual hosts Cohen Williams and Snell and Wilmer. We have delicious signature cocktails being supported by ADR Services and Adut Wolfson. Our flowers are by Cade Shuddy, and they are so beautiful. And our desserts are from the Complex Appellate Group. So thank you so much for your sponsorship this year. I also want to give a thanks to all of the committee members who helped put on this wonderful event, and all of our large board of almost 40 judges and attorneys, and an additional advisory council of almost the same number who work throughout the year, all as volunteers. There are 2 paid employees of the association. I am one of those, and our new communications associate, Georgia Johnson, is the other, and all the rest of the work is through volunteers, whether as members of the society or people who have volunteered their time to help us with our work. So thank you so much. And then I just want to extend one special personal thank you to Robin Lipsky, whom Chair Jeff Portnoy thanked before. As you may know, Robin has worked for the society for 8 years, and from my understanding, from let's say a historical perspective, along with the work of a very energetic board, she took an organization that was, let's say, in a latent phase to one that is in an extremely active phase. And not only did she do that, she set up the transition such that I could step into a very vibrant organization, and I greatly appreciate that. So we're going to wrap up the comments now and invite you to enjoy the rest of the evening. We will have food and drink. We hope that you enjoy mixing and mingling, and we look forward to being in touch with you throughout the year. Thank you, everybody.